There is a very important split of circuits that the Supreme Court is not going to resolve, at least not in the term to begin this coming October. I refer to Section 362C, which provides for an automatic termination of the automatic stay 30 days after a repeat filing within a year. If you wanted to draft a statute any more ambiguously, I'm not sure it is possible, because the critical sentence uses the phrase "with respect to" 3 times, yes, 3 times in the very same sentence. First, we had the First Circuit, which ruled that after a repeat filing, the automatic stay terminates entirely, that is to say, both respect to the debtor's property and property of the estate. Then late last year, we had the Fifth Circuit, which created the split by ruling that the stay automatically ends only with regard to the debtor's property and not to property of the estate. And this is significant because typically in a bankruptcy case, a debtor has very little of its own property at the outset, and therefore this great, shall we say, reform from 2005 was almost meaningless. The party who lost in the Fifth Circuit filed a petition for certiorari with the U.S. Supreme Court, and on the 29th of June, the U.S. Supreme Court denied the petition. That is to say, the Supreme Court is not going to resolve the circuit split, at least not at this time. There was a very important bankruptcy court decision that came down while the petition for certiorari was pending. That was a decision by bankruptcy judge Christopher Klein from Sacramento, California. The opinion by Judge Klein was cited extensively and quoted extensively in the opposition to the petition for certiorari. What Judge Klein did was to explain why terminating the stay as to all property would really be devastating in a Chapter 7 case. And frankly, most of the cases that have gone up on appeal dealt with Chapter 13 cases and did not describe what would happen in Chapter 7 cases. And I hope or think that perhaps the Supreme Court justices or their clerks took Judge Klein's decision very much into consideration and decided that, well, maybe one of these days we're going to confront this circuit split, but not now, because it's really not ready for prime time. As Judge Klein pointed out, the circuits have not thoroughly considered all of the ramifications of the termination of the automatic stay. If any of you out there have any cases involving this Section 362C, I recommend that you, of course, read Judge Klein's decision and analyze it thoroughly, whichever side of the case you are briefing. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will be back same time next week with something important in the area of bankruptcy law. Until then, be well, stay safe, hug your family, Zoom with your family, do whatever it is, but stay safe. Good day.